the Senior Competition Counsel at TechFreedom. Welcome to our second of a series of panel discussions on the FTC and its consideration of what I'll call competition-based rules. Today we have a serious group of expert lawyers and economists, and we're going to consider whether the FTC should adopt rules that limit or prohibit the use of exclusive agreements and under what conditions. Our jumping off point will be the petition filed by the Open Markets Institute asking for just such a rule, and which the FTC sought comment on a few months ago. Before I turn to the substance, let me tell you or remind you who we have with us virtually to discuss this topic. I'm going to try to be brief. They're all more accomplished than my short description will suggest. So we have Tom Lambert. Tom is the Wall Chair in Corporate Law and Governance and Professor of Law at the School of Law at the University of Missouri. Einar Elhage. Einar is the Petrie Professor of Law at Harvard Law School and founding director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics. Dennis Carlton. We have Dennis here. Dennis is the David McDaniel Keller Professor of Economics at the University of Chicago, Booth School of Business. He's a former Deputy Assistant Attorney General for Antitrust, running the economics angle there. Jay Ezrailov. Jay is the former economic advisor to former FTC Chairman Joe Simons and the founder and managing principal of Elevicon, an economic consulting firm. We have Doug Meleman. Doug practiced law for over 40 years before becoming an academic. He is currently a professor of the practice of law at the Law School of Stanford University. He was previously Senior Vice President and General Counsel of Intel and Acting Assistant Attorney General for Antitrust, and before that, Principal Deputy Assistant Attorney General for Antitrust during the Clinton administration. We also have Abe Wickelgren. Abe is the Bernard J. Ward Centennial Professor at the University of Texas Law School. He is both an economist and lawyer. My first interaction with Abe was when he was a staff economist at the FTC. And every time I run into his work as a lawyer, I say, didn't this guy used to be an economist here? Anyway, OMI asked the FTC to initiate a rulemaking to prohibit businesses from using exclusive dealing, exclusionary payments, and other similar practices that substantially foreclose rivals from customers, distributors, or suppliers of critical input. OMI advocated that the Commission, through issuing such a rule, treat as per se illegal exclusive agreements that result in substantial foreclosure of customers, distributors, or suppliers, and proposed three alternative tests for defining substantial foreclosure. A dominance test, where a firm with a share of 30% or more of a relevant market uses exclusivity with all its customers, distributors, or suppliers of an essential input. They also proposed a quantitative foreclosure test, where a firm has exclusive agreements with customers, distributors, or suppliers that together account for 30% or more of their relevant market. They also proposed a qualitative foreclosure test, where a firm ties up the top three or more customers, distributors, or suppliers in a concentrated market through exclusivity. OMI further recommended that the substantial foreclosure test be modified to treat as per se illegal, parallel use of exclusivity in oligopolistic industries, and advocated for a definition of substantial foreclosure that would find substantial foreclosure when three leading firms have a combined share of 50% or more in the relevant market and use exclusivity with their customers, distributors, or suppliers, or the three leading firms collectively use exclusivity with customers, distributors, or suppliers of a particular input that together account for 50% of their relevant market, or if the three leading firms tie up the top five or more customers, distributors, or suppliers in a concentrated market. OMI also advocated that exclusivity that is of short duration or terminable at will not be treated more leniently than other exclusive arrangements, and also suggested that the efficiencies that may be associated with exclusive agreements, either de facto or de jure exclusive agreements, should be viewed skeptically, and the court should ask whether they can be obtained in some other manner. Now, I don't mean to have us pick on OMI's petition or position, but we're using it as a jumping off point. Is such a rule or an alternative rule a good idea? Why or why not? Are there any alternatives to such a rule that might raise fewer procedural or substantive concerns? And I think specifically about guidelines, right, is a better approach for the agencies to write vertical guidelines. While they rewrite the vertical merger guidelines, should they expand that project to include vertical agreement or vertical restraint guidelines, right? The principles are the same. So now my plan is generally to give each participant 5 to 10 minutes to make some initial comments and then move to discussion. But I'd like to intersperse, these opening remarks with some discussion. For the audience, viewers, please use the question function to submit questions, and I or others will try to work them into the discussion. With that, let me turn it over to Tom for some initial comments and to kick off our discussion, and we'll go from there. So Tom, take it away.
Great, thank you, Bilal. It's a real honor for me to be on a panel with this group of scholars. These are all people whose work I have long admired. I haven't always agreed with it, and we've disagreed publicly sometimes, but I have learned a lot from everybody on this panel, and I very much respect the rigor of their thought. I'm excited to hear what they think about OMI's proposal and alternatives to it. My own view is that the proposal is ill-conceived and that it would reduce social welfare relative to the prevailing legal approach, the sort of structured rule of reason that we use for assessing exclusive dealing arrangements. So let me briefly tell you why I think that. The first thing to note, I think, is that exclusive dealing arrangements and similar practices like loyalty rebates that Einar and Abe have written on are sort of classic mixed bag competitive practices. They can reduce market output by preventing a producer's rivals from achieving minimum efficient scale or otherwise raising their costs in some way. But they can also enhance market output in a number of ways. And we've got a group of economists here who can talk about this more eloquently than I, a lowly lawyer, can. But it's just 4 examples of ways that exclusive dealing can enhance market output. One, they can enhance distributional efficiency by providing sort of a middle ground vertical integration. Producer needs distribution services. Distribution service is an input for a producer. And of course, that means the producer faces the classic make or buy decision on distribution. The producer can buy distribution by selling through retailers, charging a lower price than the retail price to the retailers. Or it can make distribution by integrating forward into distribution. If it integrates forward, it sort of loses the specialization that distributors have. It's probably not as efficient a distributor. If it tries to take advantage of distributors, professional experience, et cetera, their expertise by selling through distributors, then it has to somehow monitor them to make sure that they're doing a good job. So exclusive dealing can help here. If a distributor can only sell a producer's brand of a product, then the producer can be a little more assured that the distributor will take steps to actually make lots of sales. You don't have to worry about the producer favoring other brands, et cetera. So a way to enhance distributional efficiency by providing this kind of midpoint between the make or buy poles of the spectrum there. A second thing that exclusive dealing can do is encourage producer investments in distributors by preventing interbrand free riding. So the producer can invest in amenities at the retailer that draw in consumers, but it can ensure that its investment is not just going to benefit its rivals, that these amenities won't inure to the benefit of rivals because the distributors are not allowed to carry rivals' products. And with that assurance, we would expect to see producers invest more heavily in their distributors. A third pro-competitive output enhancing effect of exclusive dealing is that it can encourage greater output by reducing the costs that are associated with uncertain supply and demand. So a retailer needs to assure itself of a steady source of supply, and the cheapest way for it to do that sometimes without worrying about a glut of supply is just to enter into a requirements contract with a producer. And then a producer can assure itself of a relatively predictable amount of demand, basically, by entering into exclusive dealing contracts with retailers, and it can trust that demand should reflect collective demand for their wares. That predictability can lower the producer's risk, and that may lead it to expand its own output. And then finally, Ben Klein and Kevin Murphy famously pointed out that exclusive dealing can intensify competition among manufacturers for distribution, which will lower wholesale prices and should lower retail prices to the extent there's competition in the distributor market. So to induce retailer exclusivity, producers will often lower their wholesale prices in exchange for exclusive dealing. And then competition among the retailers will pass those lower wholesale prices on to consumers in the form of lower retail prices. We could therefore see lower prices, greater output with an exclusive dealing contract. Now, that's not all of the competitive effects of exclusive dealing and similar arrangements, but I've said enough to make the basic point that exclusive dealing is, from a competitive standpoint, a mixed bag. Now, anytime you're regulating mixed bags, you've got a problem. If the regulator, and by regulator, I mean to include courts here, but if the regulator or court wrongly allows an output reducing action, well, there's a loss, a false negative. If the court or enforcer wrongly forbids output enhancing actions, then we also have a loss. We're leaving, we're not getting all the output we could get. In either case, welfare is impaired. If you try to catch all the bad instances of a practice, you're likely to forbid good instances. If you try to allow all the good instances, you're likely to allow some bad instances. So the adjudicator or regulator could deal with this by just adopting a more nuanced rule that really tried to take account of all considerations. The problem there, of course, is that you raise the decision costs of the rule. So, in regulating mixed bags, the optimal thing to do would be to try to come up with a rule that minimizes the sum of error costs and decision costs. My own view is that OMI's proposed rule, per se illegality for instances of exclusive dealing that result in substantial foreclosure under one of these three tests, would not minimize the sum of error and decision costs. I think relative to the prevailing rule of reason, the Tampa Electric case, et cetera, OMI's approach would raise costs and reduce welfare. So let me very quickly say why. First, you've got the dominance test. The dominance test applies if a producer has a greater than 30% market share and engages in exclusive dealing with all its distributors or all of its suppliers of a key input. The problem here is that output reduction from exclusive dealing typically results only if there's sufficient foreclosure to hold a rival below minimum efficient scale. So foreclosure is the key. And the market share of the producer often has nothing to do with the percentage of distribution outlets that are foreclosed. So let me give you an example. Frito-Lay is the dominant producer of corn chips in the US by far, way more than 30% market share. Suppose that Frito-Lay entered into exclusive dealing arrangements with all its corn suppliers. Well, there would still be plenty of corn for Frito-Lay's rivals. Less than 10% of US corn production is devoted to human consumption, and only a very small fraction of that is used for corn chips. So there's plenty of this input that's available to a rival of Frito-Lay. The fact that Frito-Lay is a dominant firm in some particular market and enters into an exclusive supply contract doesn't suggest that there's been anti-competitive foreclosure. So the dominance test, I think, is simply an apposite. The quantitative foreclosure test, greater than 30% of the market foreclosed, well, that seems to focus on the right issue, but it's not an improvement over the current rule of reason. So the current rule of reason, I think, is better because it allows for consideration of potential pro-competitive benefits. It's not allowed in OMI's rule. And we don't get much cost saving from OMI's rule in terms of administrative costs because we still have to define the market, which is the most difficult thing you do in cases like this. Same thing with the qualitative foreclosure test. It requires defining the market. It also requires saying when a market is concentrated. And we have any guidance on that from OMI. We also have no guidance or reason to believe that 30% foreclosure is significant, or it's significant in all markets or industries. And as TechFreedom's filing in this petition has pointed out, most of the litigated cases and settled cases that have found liability have involved significantly more than 30% foreclosure. So those are my thoughts. Look forward to hearing from everyone else.
Okay, thank you, Tom. Let me turn it over to Einar, and then maybe we'll get some discussion going before we bring the economists in. But Einar, the floor is yours.
Thank you, and thank you for including me on this panel. So initial question is whether the FTC even has the authority to issue the requested substantive rule. I think the answer to that is the statute's ambiguous. One could read the statute as limited to procedural rules, as TechFreedom's response to Open Markets petition stated. But on the other hand, in 1973, the DC Circuit did interpret the statute to confer on the FTC the power to adopt substantive rules on both deceptive practices and unfair competition methods. In response, Congress did something interesting. At first, the House passed a bill that said, well, the FTC has authority to enact substantive rules on deceptive practices, but not on unfair methods of competition. But then it compromised with the Senate an amendment that actually confirmed deception rulemaking power, but did not purport to alter whether the FTC had any competition rulemaking power. I think one could read that as meaning that Congress is implicitly confirmed at that point the DC Circuit opinion that said the FTC had competition rulemaking power. But I actually think a fairer reading would be that Congress did not have the votes to either adopt or reject competition rulemaking power unless they preferred to leave it ambiguous and to be resolved by the courts in the future. So you have an interesting case where it seems like Congress is deliberately legislating an ambiguous response to the question. So given that the text and that legislative history and structure, I think, makes it ambiguous, it seems to me that Chevron deference should apply, so that if the FTC interpreted the statute to give it competition rulemaking power, the courts should give that decision Chevron deference. Would it be a sound exercise of their power to adopt competition rulemaking power? I think so, and I think that's in part because I think there's a growing recognition that a major problem with current antitrust doctrine in general is that it focuses on open-ended analysis of the welfare effects in each case, which has the effect that it makes antitrust cases very hard for judges or juries to even understand, and makes cases extremely expensive to bring and very difficult to win. So I think we generally need more rules and presumptions in antitrust. And it seems to me that a good place to start would be trying them out with FTC rules, which after all raise the smallest risk of over-deterrence, since they can't inflict treble damages or damages at all, and the enforcement is by financially disinterested and politically accountable parties. As for the open markets specific proposed rule for exclusive contracts and loyalty contracts, I agree with the open market that such contracts, in fact, are seldom efficient when they foreclose a substantial share of the market. And I don't think the literature, the empirical literature, is very compelling one way or the other on that issue. I base that on the fact that I've been an expert witness in about 36 cases involving exclusive contracts and loyalty discounts. And in virtually all of those cases, the defense was not able to come up with even a shred of evidence that they had any efficiencies, let alone any evidence that there was no less restrictive alternative and that they were large enough in magnitude and sufficiently passed on to consumers to offset any anti-competitive harm. Instead, what the defense did in virtually all these cases was simply to argue that the literature shows that in general, exclusive contracts or loyalty discounts could have some efficiencies in theory, without offering any evidence whatsoever that their actual exclusive contracts or loyalty discounts did have any efficiencies. So unfortunately, under the current doctrine, this sort of weak hand waving on efficiencies is generally enough because current antitrust doctrine first puts the burden on plaintiffs to show anti-competitive effects and has made proving anti-competitive effects extremely difficult, in part by frequently requiring statistical analysis for which no adequate data exists to perform. So the result is, under current doctrine, defendants are generally winning these cases even though there is no evidence whatsoever that their exclusive contracts or loyalty discounts actually have any efficiencies, and thus probably would have been economically rational to adopt only if they thought they did have anti-competitive effects. So I think some rule should be promulgated, and that the proposed open markets rule would be better than the existing state of law, which allows defendants to generally win despite lacking any efficiency justification. On the other hand, I do think that efficiency justifications are possible. Now, the open markets petition discusses 4 efficiency justifications, and it explains why it thinks none of them are persuasive or why they have less restrictive alternatives. But the open markets actually doesn't discuss any of the 3 efficiency justifications that I discussed in my casebook. So I don't find it a persuasive response or a persuasive showing that they never exist. And although I rarely see those efficiencies in the actual cases that are brought today, certainly not any evidence of them, that may reflect the fact that given the very difficulties of proof I mentioned, plaintiffs tend to only bring these cases when they're highly meritorious. A per se rule, on the other hand, might deter exclusivity contracts even when efficiencies do exist, since now defendants would have to take into account that whether or not they have efficiencies, it would be illegal. So I would think it would be better to amend the open markets proposal to simply say that showing substantial foreclosure shifts the burden of proof onto the defendants to actually prove a pro-competitive effect and the lack of any less restrictive alternatives. That way, if we actually had the sort of efficiencies that Tom was talking about for any particular restraint, they could still be achieved, and we would put the burden of proof on the topic on the party that has the most evidence on the issue. I think such litigation could also provide very valuable empirical evidence on the extent to which these efficiencies really exist in the real world. On a couple of other specific points, I do agree with open markets that cumulative foreclosure should be covered. In fact, Supreme Court decision in Motion Pictures already says that, specifically for the FTC Act. But I think it makes sense as a matter of economics, because cumulative foreclosure is what creates the anti-competitive effects. I also agree with open markets that terminability or short duration should not be deemed to undermine foreclosure. It seems clear to me that the antitrust economics establishes that when exclusivity restraints and loyalty discounts have anti-competitive market-wide effects, buyers nonetheless have individual incentives to agree to them in return for trivial discounts from the anti-competitively inflated price, mainly because they externalize almost all of their contribution to anti-competitive effects onto other markets in their same, other buyers in their same market, or down to downstream markets, as work by Abe and myself, and also Mike Winston has shown. So as a result, the very same incentives that cause buyers to agree to anti-competitive exclusivity in the first place would also cause them to renew contracts of short duration and to decline to terminate contracts when they're terminable. So there's no inconsistency between terminability and short duration and anti-competitive effects. So an exception based on that is economically incoherent. Unfortunately, there is a split in the courts right now. Half of them accept this mistaken position that terminability or short duration should undermine foreclosure. Half do not. So it would be particularly good, I think, for the FTC to adopt a clear rule rejecting such an exception. Thank you.
All right, thank you, Einar. So we've got 2, in fact, 3 economists in the queue. But let me open it up to either Doug or Abe if they have any questions or comments on what they've heard, and then we will go to Dennis and to Jay. So, Doug, anything?
Yeah, I have. Let me just give some thoughts, and a couple of them may imply questions that the speakers can respond to. I just want to say I completely agree with Einar on the importance of duration that is to say, the unimportance of the duration of any kind of understanding about exclusivity, because in many cases, at least, if you imagine some anti-competitive story, the promisee is using some kind of leverage to induce the exclusivity, and the fact that the term of the agreement is short isn't going to change its ability. Like, for example, a threatened refusal to deal, like in Densply, to obtain exclusivity. Similarly, I agree that it's kind of silly to have a per se rule. I would put it slightly differently from the way Einar did. I think what we're talking about is a set of practices that's extremely heterogeneous in terms of the natures of the participating firms, the natures of the market and the market structure of the competitors and so on. And to say that even if in general we thought exclusivity of a certain type was likely on balance to be anti-competitive, that we should make it a per se rule strikes me as a little nutty. But three more small points where I have a couple of reservations. I would start with the following question, kind of taking as a jumping off point what Einar said about the law, and I kind of agree with the bottom line, it's unsettled. One question is, if you're the FTC and you want to test, flex your muscles here and establish rulemaking authority, why would you pick exclusive dealing? And I say that because another way of putting the question is, what's the problem? Whatever we think of the economic desirability of exclusive dealing, it doesn't strike me as an instance in which there's a lot of anti-competitive exclusive dealing that really matters, that isn't the subject of effective antitrust prohibition or remediation. There's a lot in the patent area, in the platform area. There's all sorts of conduct that looks pretty bad to me that the antitrust laws have ignored. I don't see the rules about exclusive dealing that have evolved in the rule of reason context as being insufficient to deter anti-competitive exclusive dealing. So if you want to go to court with an attractive record, I'm not sure I'd pick this one. Or just two things. Well, one, I want to say a little thing for Tom. You kind of blew by this, and you said the issue in exclusive dealing is whether an equally efficient competitor is excluded. I understand there's a lot of law about that, but I do think it's worth, when we're considering these policy questions, to bear in mind that the most efficient of less efficient competitors can be an important competitive constraint on the leading firms in the market, and it's an interesting.
Seems like everything froze. Anybody else hear anything?
I can hear you, Einar.
Right.
Doug is
Okay, Doug may be offline in a sense. Let me ask Abe if he's got some comments before we do turn it over to Dennis and Jay, the economist. Well, Abe is an economist too, to comment on what he's heard. So Abe, any thoughts?
Yeah, so I mean, I generally agree with a lot of what both Tom and Einar said. I would say, I think, Einar mentioned, but I think it bears, greater emphasis that the cases that Einar has been an expert in, that's those cases are based on the equilibrium phenomenon of, what cases are winnable, right? And I think it bears emphasis that given the way our law currently is, you wouldn't expect anything but the worst, exclusive dealing cases to be brought. And so, I don't think we can draw much in the way of conclusions. And I think that's generally going to be the case. I think, as Doug mentioned, the heterogeneity of possible, exclusive dealing arrangements is so large that we should expect to see, I think, given that there are substantial both anti-competitive and pro-competitive effects, that we should expect there to be a lot of both. And I think that suggests that per se rules are probably not appropriate. I don't think this means that we have to do nothing, right? I think there are lots of possibilities for exclusive dealing because of the contracting externalities that Einar mentioned, to solidify market power and exclude rivals to the detriment of consumers. I think we just need to have courts and enforcers that are more open to those sorts of things. And it's unfortunate because it's not specific, and it's not it doesn't generate immediate action. But I think there's not really any substitute for just saying what we need is better judgment on the part of the decision makers in this context, and that trying to come up with per se rules when something that is so heterogeneous, and for which there's so many possibilities for pro-competitive and anti-competitive effects. It's just not something that we can probably describe precisely enough in advance to generate rules. And it seems like it's a classic case where standards or guidelines, as Bilal mentioned, is a far better approach. Those guidelines speak more critically about the dangers of exclusive dealing, to send signals to courts about where at least where the enforcement agencies are, and hopefully where the economics is on this. But I don't think that there's much more that we can do than that.
Okay, well, let me give Dennis and Jay a chance to make some remarks. We'll start with Dennis, and I think they can also react to some of what we heard on the economic analysis that is required to get a good sense of whether these agreements are anti-competitive or not. So Dennis, I turn it to you.
Okay, thank you. And thank you for inviting me to be on a panel with such smart people. Based on what I've heard so far, I would have to say people have given a pretty good summary of the pros and the cons. And even though I might disagree with some of them, I think it's a very useful background. So my views are going to be purely economic. I'm not a lawyer. I would say I was stunned by the boldness and the lack of theoretical and empirical support of the OMI proposal. I think it's pretty well understood that vertical restrictions of a variety of types, including exclusive dealing, can in certain circumstances promote competition, and in other circumstances can harm competition. That doesn't get us very far. It means that you need some empirical justifications in order to make sense of how you're going to balance these two. And I'm not aware of any studies in the economics literature, at least, that would provide a justification for something like 30% cutoff. Or, and although this is a bit of a legal view, I used to teach antitrust in the law school with a lawyer. No studies justify the confidence I think you would need in order to promulgate a per se rule, which is really what you need if you want to just ban a practice that the outcome is so harmful. So let me look a little bit at the evidence that they cite in that OMI report. The first thing they do, and is understandable, is they cite legal cases. And one of the things about the legal cases they cite is that, as TechFreedom points out in their comments, all of the market shares are way in excess of 30% for the cases they're citing. So that doesn't provide a justification for 30%. But there's a more fundamental point, and Abe hit on it, and that is, this is a self-selected sample. If I want to see, is exclusive dealing a good or bad practice, I don't want to look at the most egregious antitrust cases where they were found to be harmful. what I want to do is take a sample of firms that are engaged in the practice and ask how many times is it good and how many times is it bad. And what I always taken as an example, an excellent example of a study like that, the FTC studied resale price maintenance in the, I think it was in the 1980s. And they have a very large volume where they say, you know, I'm going to survey firms that are doing this. Let me look at what happens when they do it, when they don't do it. Why are they doing it? What is the size of firms that are doing it? That's the right way to try and analyze, if you want to do it systematically, whether a practice is good or bad. Now, the OMI study does refer to the empirical literature in economics. And in particular, they refer to a study by LaFontaine and Slade that surveys many studies that were done in the economics literature. And they basically they're dismissed as not, you know, being all that careful. And I went back and looked at the studies that they cite. So let me just tell you what the facts of those studies were. Now, there's no question studies can always be done better, but there are 12 studies they survey in which they asked, were the voluntary decision to engage in these practices, did that lead to an increase in social welfare? And 8 out of the 12 found that consumers were better off. They also did a study of 11 studies in which, and this is important, I'll come back to this, the state government interfered with the ability to engage in certain types of vertical contracting. And in 9 of those 11 cases, the interference was bad. So to me, you're swimming upstream if you want to have a per se rule with a low market share. Let me now turn to the theory in that in the OMI report proposal. Now, I actually thought Tom and I did a very good and more thorough job of explaining some of the theory, but let me just talk about 2 things. One that they recognize in OMI is they say free riding. So if I'm a manufacturer and I invest in, say, training a firm, a distributor in how to sell my product, how to repair my product, whatever, then there could be free riding. If a competitor could use that same distributor, that's understood. OMI understands that, but they say it's easy to prevent. Make the distributor pay for that training. Well, an upfront fee by a distributor could solve the problem in some circumstances, but just think about asymmetric information. How does the distributor know my product is going to be a good product? How does the distributor know that I'll continue to promote my product? In cases of asymmetric information, you can't solve a problem the way they're suggesting. Moreover, they completely ignore, and there's no discussion as far as I can tell, about a very important branch of distribution in our US economy, franchising. What are the implications of their rule for franchising? Doesn't a franchisor have the right to protect his reputation? An individual franchisee who cheats on the franchise, quality hurts himself, but he hurts the franchisor perhaps much more. So there are justifications for that. That's not considered at all. There is a consideration for something Tom talked about, namely having a steady demand from your distributor, and they in order to get enough volume. And they say, well, that's easy to achieve. Just give discounts, volume discounts. Well, wait a minute. If you start giving volume discounts, you're right back into creating incentives for exclusive dealing. So one of the solutions they give to steady demand for large volume would get them into exclusive dealing. So I was unconvinced that their dismissal of free riding and justifications for exclusive dealing can easily be handled. They completely ignore that any restrictions they place on vertical arrangements between distributors will simply create incentives for more vertical integration, and that could be undesirable. So let me just wrap up and saying what my recommendations would be. The first would be, let's look at state restrictions that interfere with vertical restrictions. Now, that's a traditional function of the FTC. And I think we would benefit if we could lift some of those restrictions. Second, I think vertical guidelines for a whole bunch of vertical practices are completely sensible. And that could be based on a more exhaustive study of these vertical practices in a more scientific way than just self-selecting by cases. But I want to end by really addressing something Ina raised and Doug, I think, was going to allude to. I think it is a problem because I've been in vertical restriction cases on both sides. And, you know, there is a sentiment, I think maybe among practitioners who have an advantage of understanding the stuff perhaps better than economists, that under the rule of reason, it's really hard to win one of these cases if you're a plaintiff. And that means the balancing that's being done in the courts, if that's what you think, that just means the balancing that's being done in the courts is not being done appropriately. And having an exhaustive study, a more exhaustive study of vertical practices would help your prior beliefs as to whether the stuff is good or bad. And there's no substitute for looking at the details of a particular case. But as Ina said, sometimes there aren't enough details that you can do a study. And I think having a more exhaustive analysis might help. If you're worried about the rule of reason being stuck in the wrong place, it would help judges have a better idea of how to balance things. I'll stop there.
All right, thank you, Dennis. Let me go to Jay and see if he can expand on or agrees and disagrees with Dennis and others. And then I think I may go back to Ina for a moment, just to let Ina react to a few things that have been said. And we'll go that way. So Jay, take it away.
Thank you, Bilal, and thank you, TechFreedom, for inviting me to be part of this great panel with a great, smart group of people. So first, on the question of whether the FTC has authority to make substantive rules on conduct as unfair methods of competition, I defer to the lawyers on this question. Instead, I'm going to discuss whether such rules are a good idea from a policy perspective. So is the OMI proposal a good idea? I think I agree with many of the people on the panel. I think no. I think that it's not a particularly helpful proposal. It's somewhat extreme and draconian. The proposal would make exclusionary conduct a per se violation with a very low threshold for determining what constitutes an illegal exclusionary conduct. And it does not recognize valid business justification for exclusive contracts. The proposal would also reject short-term contract duration as a defense. So I disagree with some of the panelists. I think that for some classes of economic models, longer contract duration is a critical element of the theory of harm. I'm thinking in particular of the Aghion-Bolton model. So a categorical rejection of contract duration as an element of analysis may not be justified. And there's really no empirical basis for the OMI proposal. So what's the rationale for the proposed rule? The petition argues that rules to prohibit exclusionary conduct are needed because harms from this conduct are real and justifications are of limited relevance, particularly for dominant firms, and that governments and other enforcers are wasting resources in litigating these cases in court. I think this is a very misguided rationale for the proposed rules. The petition discusses how it's very difficult for plaintiffs to win conduct cases in court, and that plaintiffs have a very poor winning record in such cases. If harms are real and justifications are really not relevant, why aren't plaintiffs able to convince the courts? The proposed rule asks us to adopt a general rule prohibiting exclusionary contracts without offering any real evidence, so they need to adopt the rules. At the same time, plaintiffs in individual cases are unable to convince courts in many cases that harms outweigh benefits. when they actually have some evidence to offer. So the petition assumes harms, but no benefits from exclusionary contracts, and it offers no plausible basis for this proposition, just some speculation and I would say faulty logic. And I think Dennis did a very good job of going through exactly what's wrong with some of the rationale. So what's the evidence of harms and benefits from vertical restraints? I think Dennis talked about the LaFontaine-Slade meta study, literature review that goes through some of the studies on the effects of vertical restraints. And as Dennis mentioned, overall, the study finds that there are benign or output enhancing effects of vertical restraints, and in particular, exclusive contracts. But it's important to note that there are very few of these studies, and they focus on, very small set of industries. So we should not draw too much from this finding. And I think it certainly is an empirical possibility that there's far more harm from exclusive contracts that the studies are finding. So we actually need, I agree with Dennis, we need a lot more empirical research on the effects of vertical restraints to understand if we need different standards for assessing conduct, for assessing exclusionary agreements. But we really shouldn't adopt broad rules without evidence of a problem that the rules are supposed to solve. As far as the, what can we tell about the evidence or how likely harm is from an exclusive contract? I agree that much of the arguments are theoretical. I agree with Einar that there is very often the arguments are theoretical, not empirical, and we need actual evidence. I think that the theory is very compelling, but it shouldn't be a theory alone. That's the basis for policy. So I definitely need more studies. However, I think one point of reference that is important not to ignore, that speaks to potential evidence of the benefit of exclusionary contracts, is that exclusionary contracts, exclusive contracts are everywhere. They're omnipresent. I think there is an estimate that roughly around 30% of all distribution in the U.S. economy is exclusive. Dennis mentioned franchises, which are exclusive, which are a form of exclusive distribution, and they account for a very large part of the U.S. economy. But it's not just franchises. Exclusivity is everywhere in our society and the economy, and we need to look no further than the legal profession for evidence of why exclusivity is important and a good business justification. Law firms cannot represent two sides of a dispute. There's a clear conflict, and there's good reason to make representation exclusive. But when it comes to distribution of goods, distributors are often distributing goods of competitors. They do have a conflict. So resolving that conflict through exclusivity is clearly a benefit. There are other clear benefits for exclusivity that the OMI petition kind of glosses over, but there really are significant, such as free riding and economies of scale. The economic models of exclusivity all rely on presence of significant economies of scale for harm. So you cannot have harm within without significant economies of scale. If economies of scale are important for entrants or firms looking to expand, they're also important for incumbents. So it's, one shouldn't just ignore these benefits that we understand are pretty important. So one other thing I want to say is about the standards themselves. The OMI petition talks about how rule of reason offers little guidance to businesses about what constitutes illegal antitrust conduct. And I agree that the current standard does not provide a lot of clarity and generates a lot of risk and uncertainty for many firms. But the OMI proposal does not make conduct standards any clearer. On the contrary, the petition proposes vague and unworkable rules that would generate even more risk and uncertainty. For example, under the proposal, a firm's contracts may be deemed a per se violation based on the contracting terms of other firms in the market, even if the potential violator can't see what other firms are doing in terms of their contracting. So I think that the clarity of standards is a major problem that needs to be addressed, and I agree with Einar that having an open-ended inquiry that starts from basic principles to determine whether a particular contract term is an antitrust violation, it may be impractical and generates a lot of uncertainty. Very difficult to bring these kinds of cases. So rules are not, but the rules are not necessary for more clarity for businesses about what constitutes illegal antitrust conduct. Instead, there could be more clear guidance from enforcement agencies. The agencies could offer conduct guidelines, and courts could offer more guidance. I think the issue is that we really need to understand the effects much better from an empirical point of view in order to be able to offer more clear guidance about the specific types of circumstances where harm is likely to outweigh benefits. So I see the issue of uncertainty of standards as one of the biggest challenges in antitrust today, particularly when it comes to assessing firm conduct. We need more practical standards. Rule of reason creates a lot of ambiguity for firms, which can weaken competition. So, so the uncertainty associated with conduct standards really not good for competition. I think we need to make standards more clear and better, so that we don't discourage firms with maybe small but real benefits from exclusionary conduct, from engaging in that conduct, but at the same time discouraging potential violators, discouraging people from using exclusive contracts in an anti-competitive way. So we need.
Jay, let me go to Einar and give Einar
Okay.
and Abe a chance to respond.
Okay.
Einar, take it away.
Sure. So first off, I'd just say thank you for all the responses. I don't think any of them, though, so far offers an explanation why a substantial foreclosure share should not at least shift the burden onto the defendants to show pro-competitive effects, which is what I have suggested. But since no one here is defending the open markets position as is, let me offer one defense on one point at least. So I think many, maybe all the responders have so far said that, well, clearly they're wrong to say we should have a per se rule, because these agreements sometimes have efficiencies, and thus a per se rule would sometimes get it wrong. I just want to point out that is unlike the way law and economics treats the choice between rules versus standards in every other area of law. Instead, what the law and economics literature realizes is all rules are over-inclusive and under-inclusive. 65-mile-an-hour speed limits sometimes lead to bad results because driving 66 is just fine, and desirable in the circumstances, and they're sometimes under-inclusive because driving 64 is dangerous given road conditions. Nobody thinks that because rules are getting it wrong sometimes in these other fields, therefore we should have some open-ended standard of, let's say, drive safely. That should be our rule instead. Instead, the question is a practical one of, is the rule leading to more over and under inclusion than the standard would in application? Because even if the standard is perfectly identifying the relative norm of social desirability, either driving safely or avoiding anti-competitive harm and protecting pro-competitive efficiencies, it's going to lead to a lot of errors in practice and a lot of under-deterrence because of the expense of it. So, you can't just say because this rule is over-inclusive that it's not better than the current results we're getting with the open-ended standard. It's really an empirical question of which leads to more over and under inclusion in application. And I don't see anybody presenting the empirical evidence to show open markets is wrong, that their rule would produce less of it than the current doctrine. I myself think the middle position would be better because I'd like to have the safety valve of having defense be able to prove pro-competitive effects when they exist. But I don't think empirically anybody's shown the open markets position is worse than the current law. One other just point Jay mentioned on the duration relevance. He suggested that the rejection of duration relevance is not justified because under certain anti-competitive markets like Agion and Bolton, it can matter. One, I would just say I've never seen a case where the actual model of anti-competitive harm is the Agion and Bolton model. It's a very specialized model. It's usually not what's going on. But anyway, the doctrinal issue here is not whether duration could be raised when it's relevant to a particular theory of anti-competitive harm. The issue is whether antitrust law should, as some courts have held, provide that short duration or terminability negates foreclosure in all cases and thus immunizes the conduct. That, I would say, there's no coherent economic basis for.
Yeah, could I just respond briefly? Einar, I agree with you about the evidence. I don't think anyone is saying that just because you can think of a theoretical possibility that exclusive dealing or vertical contracts can be pro-competitive, that means we shouldn't have a per se rule. I think instead, at least what I was saying is the existing evidence shows that exclusive dealing, and Jay alluded to this, is everywhere. And it's in unconcentrated markets as well as some concentrated markets. So to say that there's no evidence that a rule that goes down as low as a 30% threshold is unlikely to have harmful consequences, I think is just wrong. I think it would. But I agree with you thoroughly that I'd like to have more evidence if I want to know exactly when I'm doing a rule of reason, how to trade things off. Now, in terms of trading things off, and again, this is more sort of a legal process, but I think there is a decision theoretic component to it. The larger the effect of the exclusive dealing on what the plaintiffs are claiming is foreclosure and the harmful effect, that could certainly require a court to want to hear more and more about the efficiency justification for the practice. Just as in a merger case, from an economic point of view, again, not from a legal point of view, the larger the increase in concentration, the more I think you have to explain why you shouldn't worry about it. And that could affect how you trade off a rule of reason. That goes really to the legal process of rule of reason. As far as foreclosure, though, I do agree with Jay that the length of a contract can matter. I agree with you, Einar, that doesn't mean that a short term, you get a free pass if it's short term. I mean, there are plenty of articles that explain why that's not true. However, there are a lot of articles, and in fact, I've been involved in cases where the possibility of a long-term exclusive contract prevented an entrant from coming in at efficient scale, except over a very long period of time. So therefore, in those cases, I think the length of contract can matter if that's the theory of harm.
Let me just respond on one thing there. The argument that our assessment of the likelihood of efficiency should include unconcentrated markets. I think that's mistaken because the proposed rule only applies when there's a foreclosure share over 30%. So the relevant set of cases is in cases where the foreclosure share over 30%, how many of those are getting by even though they're inefficient and anti-competitive? So it's, to me, it's like when people say, well, if it's a drunk driving law that's over 0.1% alcohol, we should prohibit driving. If you include a set of driving that's below that percentage and say, well, a lot of that's really desirable, that's neither here nor there. And that's what I don't think we have really empirical evidence on.
I agree with that. I agree with that. You want to focus on whatever the rule is. I think 30% is the wrong number. But what I would view is what you really want to see is a survey, and this is kind of what they did for resale price maintenance, for various types of market structures. How often is exclusive dealing used, and is it good, and is it bad? The fact that it's being used often in unconcentrated industries just tells you there's some likely efficiency justification. Does not tell you there's always an efficiency justification. That's for sure.
So let me do this. Let me ask Abe to react or to make some points that he'd like to make, and then I also want to come back to Doug. I didn't mention this at the beginning, but I have a strong recollection that Doug wrote an article or gave a speech on what I remember being sort of a stepwise approach to vertical agreements, which laid out sort of a framework for thinking about whether vertical agreements are problematic. And it was a long time ago. I'm just raising it now for Doug, but if Doug can walk through that might be of interest. But let me turn it over to Abe to react to what he's heard or to make some new points.
Great. Thanks a lot. And let me just echo everybody's, thanking you for including me in this distinguished panel. And I think everyone has made a lot of very good points. I guess just my main concern here with per se approaches is, I think, in addition to the points that a lot of other people have made, I think this per se is different from the speed limit example that Einar gave, or when we talk about rules versus standards in law and economics. Typically, one of the benefits of rules is this idea of reduced decision costs. I don't think we get that here because nothing about this rule is easy to measure, right? It's not like we can stick a radar gun at somebody and say, okay, what market are you in, right? And what is your market share? As Dennis pointed out, even what constitutes exclusive dealing is not clear, right? There's lots of things that can be quite close to exclusive dealing, but aren't literally exclusive dealing, but have a lot of the same effects, right? So we don't get the same sort of clarity and ease of decision making and clear signals to the business community when we move to a per se rule like this. And I think the other problem is that you end up still with litigation, but your litigation is over the wrong thing, right? The litigation becomes, what exactly is the market here and what is my share? The litigation becomes, is my conduct really equivalent to exclusive dealing, or is it far enough away that it's not really covered? When what we really ought to care about is this exclusive dealing on balance better for consumers or worse for consumers? And rather than creating a bunch of proxies, which are maybe somewhat correlated with the right answer, but are much less correlated with the right answer than if we actually ask the question directly, I think we haven't really eased our decision because these proxies aren't simple proxies. They require just as much litigation and debate as the ultimate question. We might as well just ask the question that we really care about, right? Now I don't think that doesn't mean that we need to do nothing, right? I think the fact that we see these sorts of extreme proposals is an indication that there is I think, legitimate dissatisfaction with the current, the jurisprudence around exclusive dealing. It is too hard for, for plaintiffs to win. And I think Einer's suggestion about shifting the burden of proof is a reasonable one. Personally, I think that in some sense, the whole concept of any non-trivial burden of proof here is part of the problem, right? That, and I guess this somewhat echoes what Dennis said is, the amount of burden of proof you need for pro-competitive effects is going to depend on the evidence for anti-competitive effects. But that also goes in the other direction, right? And this, I think, is, in some sense, a problem we have with looking necessarily saying the plaintiffs have to establish the anti-competitive effects first, right? If we're in these cases that Einer talks about where there aren't, the defendants can't come up with any real plausible pro-competitive justifications for why they needed an exclusive contract in this particular situation, that tells us something about the likelihood of anti-competitive effects, right? We know that, the business is taking this action because it maximizes their profits. It can maximize their profits through, more efficient distribution, through increasing the quality of what they provide to the ultimate consumer, right? Through efficiencies. It can also maximize their profit through excluding rivals. If they can't you a good story as to how it maximizes their profit in a way that ultimately benefits consumers, then that gives a lot more credence to any arguments about anti-competitive. And the argument goes in the reverse. So it doesn't make sense in my mind to really segment these at all, right? These should be discussed together, and we should use the strength of the evidence on one side to affect our views on the strength of the other side. But I'm definitely sympathetic with Einer's idea of putting, the pro-competitive justifications to be much more central, because I think, the business, individual defendant should know their business better than anybody else. And if they can't come up with a plausible pro-competitive justification for this contract, is desirable in a way that benefits consumers as well as their own shareholders, then I think that tells us something. So, I think for my view, that would be kind of the best way to reorient this and take a more critical look at exclusive dealing, but without getting to sort of the rigidity of rules here, which, ultimately is rigid, but not simple. And thus, I think basically gives you kind of the worst of both worlds.
So Doug, let me turn it over to you for some comments. And I'm not sure if you've looked back at your stepwise speech or article, but if you have, maybe bring us up to date on your thinking there.
I'll do that. I'll say a couple of things first. First, I want to apologize for having lost internet in the middle of this conference. If nothing else concrete comes from this conference, I can promise you one concrete thing is I've finally decided to replace AT&T as my internet provider. In any event, let me make a few comments that I think in some ways weave between or among what's been said here, but maybe put it in a slightly different framework. First of all, I don't think there's much disagreement on this group, or really in the world as I understand it, about the economics of exclusive dealing. That's a fairly well understood field, I believe. And so I think we all understand it can have some benefits, can have some harm. The more foreclosure, the larger the share, more likely to be harmed, and so forth. But that's not where the action is. I think where the action is on the sort of legal process normative question of how do we deal with this. Now, I start with the following sort of basic point. The real contribution of antitrust law to economic welfare is found not in the litigated cases and the remedies issued therefore, but rather in the effect of the antitrust law as kind of a general deterrence on the multitude of anti-competitive acts that is deterred by a sound antitrust law, and the multitude of pro-competitive acts that is not deterred by an overbroad or ambiguous antitrust law. Okay. That takes us then to the question of rules versus standards in a sense. And one way I look at it in the context of antitrust is a distinction between what I call specification errors, by which I mean the extent to which the rule doesn't precisely track to the objective function. The objective function here, I think, is economic welfare. So every time you have a rule that says, whenever you have 30% of the dealers tied up, it's illegal, you're going to have a departure because you're going to be having some false positives. And you may have false negatives if the implication is that below that's a safe harbor. Those are specification errors. A more general rule, like sort of what I understood, maybe wrongly, Einer's characterization of current antitrust law to be, which is a kind of open-ended inquiry into economic effects, may map pretty closely to your objective function because we have a lot of application errors because you're going to make mistakes in getting it wrong, partly because of transaction costs and the like. And you have to look at some of those errors, not just in the litigated cases, but in how they percolate through the economy in sort of in terms of that deterrent function. Okay, let's look at current law. I suggested earlier that I didn't understand why this is the starting point for rules, because I don't understand there to have been a lot of exclusive dealing, meritorious exclusive dealing cases that have been lost. I would say something very different in other areas. But I think the current antitrust law is not what Einer said. I think it can be reduced to one sentence. All of U.S. antitrust law at a conceptual level. Private conduct that increases market power other than by efficiency-based competition on the merits is illegal, period. Private has to do with the NOR issue. There's a causal element there, but basically there are two substantive elements. Anti-competitive conduct, meaning conduct that tends to create market power and doesn't have any efficiency properties, and an increase in market power compared to the but-for world. All antitrust laws about that. There are a lot of micro rules implementing that, like some of the rules of thumb about exclusive dealing under Section 1, it's got to be 20% foreclosure or 30% or whatever, that are in aid of that basic objective. Okay, so I think that statement of antitrust law, which I believe is conceptually correct, maps pretty closely to the objective function. So the problems in current antitrust law are almost entirely going to be on the application error side. And there, I think antitrust law has become too lax. I think it does need to be more aggressive. I'm not sure we want to have rules. I'll get to that in a second. But I like the idea of guidelines because I think guidelines can help the deterrence function. They can help educate courts. And I like the idea, if we find problematic conduct, particularly with firms with large market share, of shifting the burden of proof as a way of ameliorating what appears to be, particularly in the rule of reason, too many victories for the defendant. Okay. When you look at the rules, one of the things we haven't talked about, at least except for the period perhaps when my internet was down, is what do we mean by exclusive dealing? It isn't defined in these papers. And I see at least three basic differences that are quite important. One is an agreement. A distributor agrees it will be exclusive for X number of years. That distributor is unavailable to competitors during that period, and that creates an analytical basis for concern. Another is the absence of an agreement or a short-term agreement backed by an explicit or implicit refusal to deal threat or some equivalent punishment. That's the one where duration doesn't really matter, because if Densply says to the distributor, yeah, you're contractually free to go, but if you do, I'm going to cut you off. And if the distributor needs access to Densply, it's tantamount to having a perpetual contract. And the third is where you have a unilateral contract or an offer for a contract, like most of the loyalty discount cases. Now, there's an argument that loyalty discounts have so little to be said on the justification side, we should just make them illegal or at least treat them like exclusive dealing. But if we don't accept that argument, if we think risk sharing or other rationales for a loyalty discount might in some cases be legitimate justifications, then we have to ask the question whether a discount attribution test is really the way to think about loyalty discounts, because that, at least in principle, is going to map onto the equally efficient competitor standard for what rivals are we trying to protect here. Has normative problems, but maybe it's a useful shorthand. So I think it's really important to distinguish all that, and I don't think the proposals do. And I think once we start going down this path, we're looking at rules that are likely to have, no matter what we try to do, I think huge what I call specification errors. And it's certainly not clear to me that they're going to be less than the application errors, and therefore the rules would be justified. Okay, in response to what Bilal said about my earlier article, the basic argument there was in defense of this, what has now come to be known as the no economic sense test. And that's what I used to use when I counseled clients. Client would come to me and say, I want to do aggressive conduct A. Here's why it's going to build a better mousetrap. I would say, let me ask you a question. Sometimes it wasn't one question. Would you do this if it didn't harm your competitors? Just for the efficiency? If the answer is no, I'd say you're kind of in trouble here. You know, if you've got market power, you're big firm. The answer is yes. I say, okay, if we can prove that, we're in good shape. Now, I was more optimistic about the law going in that direction than I think it has. But the point I'm trying to make is, in principle at least, a no economic sense test has the virtue of letting us identify situations where an exclusive arrangement or other vertical restraint has in effect been paid for by the efficiencies, or whether it has been paid for by the exercise of market power by the promisee. And that does strike me in principle as a useful distinction between benign and malign vertical restraints.
Thank you, Doug. Let me give Tom an opportunity to get back in here. Tom spoke first, and I think he's been waiting with some reaction since then.
Well, this has been extremely informative. A couple things to say. Just Einar, in response, I may have given a wrong impression. I certainly don't think that because rules are over-inclusive, they are never appropriate. I mean, the whole point of that sort of minimize the sum of error and decision costs is to try to come up with the approach that, you know, is optimal. And sometimes that's a rule, even though rules have really low decision costs. A genuine per se rule has a low decision costs. It may have higher errors, but it might be worth it. So I have no problem with what you've said. And I like a lot of, I'm very much open to the idea of having some sort of a burden shifting scheme that is really economically informed. So, you know, Dennis's idea that we should be doing studies like the FTC did on resale price maintenance to try to figure out under what circumstances do we see reductions in output from this practice, and under what circumstances do we see increase in output, and then craft some sort of a rule around that makes a lot of sense to me. I mean, one question I have for maybe you, Einar, or anybody else who really knows the law well on this, is how different that is from sort of how these cases really do get handled in the courts. I mean, I have the sense that under this, the sort of qualitative foreclosure test from Tampa Electric, we start by looking at the percent of the market that's foreclosed. That's the starting point of the analysis. It's not the end of it. But then you ask the question about like actual effects stemming from the practice, et cetera. But then in practice, basically, the evidence required on effects is you have to show more pro-competitive benefit as the percent of foreclosure gets higher. That's sort of the sense that I have of how those cases work, but I might not have that right. In any event, I like that idea quite a lot. That's the sort of approach that would minimize the sum of error and decision costs. I also like Doug's idea of incorporating the no economic sense test. It is, as Einar has pointed out in a great Stanford Law Review article, we have no great single test for identifying unreasonably exclusionary conduct, but of the ones that have been proffered, I think that's one of the best. So that makes a lot of sense. Abe makes, I think, the point that I was trying to make more articulately than me, which is that the OMI proposal gives us kind of the worst of all possible worlds. We get reduced accuracy, so higher error costs, because you can't consider efficiencies, actual effects, all of that kind of stuff. It's a per se rule, but it's a very costly per se rule. We don't get administrative savings. So, one of the examples that they give, in which I think just shows how difficult this is they talk about a record label that signs exclusive contracts with 3 top 40 radio artists. They all had top 40 hits in the last year. They all agree to release albums exclusively through that record label. And OMI says, well, that's okay, because last year there were 140 artists that had a top 40 hit. So 120, 3 out of 120, is not too much. But that just sort of implicitly assumes that the market here is artists with recent top 40 hits. I mean, what if the 3 artists are the only 3 reggae artists to have a top 40 hit? If we define the market as reggae artists with top 40 appeal, then the per se rule is triggered. Or what if it's, crossover country artists, and there's like 12 crossover country artists with hits, but with top 40 hits, and the agreement is with the top 3 of those. We might even if we agree that crossover country artists is the relevant market, we have to figure out if a market of 12 is a concentrated market or not. So, I mean, it's just mind-blowingly complicated to actually implement these rules. And as Abe points out, we're going to have gobs of litigation over stuff that doesn't really matter. So, my view is that the current rule of reason operates sort of in this burden shifting way that we would like. It'd be better if we had more information about, what level of foreclosure is really problematic, et cetera. If we could get that, and the FTC could write some guidelines on, generally how the analysis should proceed, I have a hunch they would be extremely influential in the courts, and they could provide, guidance to parties, et cetera. But I just think that this sort of a rule is a bad idea. It's not getting us any administrative cost savings, and it's increasing error.
So we have about 8 minutes left, and I'd like to let everyone, if they'd like, do some summation, but recognizing we have 6 people, maybe 5 if I consider that Tom's summation. So keep in mind as you do your summation, we're looking at 1 to 2 minutes, and maybe I'd like to start with Jay and then move to Einar, and then Abe, Dennis, and Doug. So if that works, I'll ask Jay to make a few short comments, and then ask Einar, and we'll go from there.
All right, thanks, Bilal. I'll try to keep it under 2 minutes. So first, I think that it is important to recognize that there's real harm from exclusive contracts and exclusionary agreements. But before we adopt very broad rules, they need to be based on empirical evidence, which we do not have. As far as burden shifting, I think I disagree with the notion that the defendants really don't need to show anything in terms of pro-competitive justifications. It's not like they can just say the words free riding and they're all fine. I think the fact finder is going to evaluate the evidence based on offered justifications and determine whether they're valid or not. And then finally, I want to pay tribute to my old friend, Janusz Ordover, who passed away a little bit more than a week ago. And he was one of the early thinkers, pioneers in the field of antitrust in general, but he contributed quite a bit to the discussion on monopolization and conduct standards, and in particular, developing the profit sacrifice and or no economic sense test that Doug talked about, which I think is really a very very valuable framework to build standards on, and we should continue to do that, more of that. So I'll stop there.
Okay, Einer?
Yeah, so first, I want to agree with the sentiment expressed by several people, including, I think, Dennis and Abe and Tom, that really it would be best if courts were thinking about pro-competitive justifications and anti-competitive effects at the same time. If there's a really unconcentrated market, there's got to be something efficient going on for it to explain why firms without market power are using it. But by the same token, if there's no pro-competitive justification, then the anti-competitive explanation becomes the only plausible one. So Tom asked, well, what are courts actually doing? And Abe was suggesting they should do this, but I think sadly they're not. They are instead imposing a very absolute burden, first for the plaintiffs to prove anti-competitive effects, but also to establish sometimes often very formalistic notions of what foreclosure means. Something about the word foreclosure often bamboozles, I think, courts into thinking, oh, it has to be absolutely impossible to make a sale, when in fact all you really need is a restraining effect in these economic models that has an anti-competitive effect in order to matter. So there's all kinds of burdens like that being imposed, even when the defendants have not come up with anything. When they really do, all they say is, oh, free riding, but do not tie it at all to what they've done. In particular, like there's a lot of cases where they might say, well, because of the restraint, we were able to achieve economies of scale and pass on cost savings to the customers. That explains our loyalty discount or why this is good. But if you're really doing that, you would think you'd have some engineering study that measures your economies of scale you're gaining, and because you have to take that into account in your pricing behavior and why does it justify this discount? No evidence like that in these cases that we see, and just no concrete evidence of the efficiencies. So I do think it would be good if, at least out of this discussion, there was some consensus that there should be some burden, I guess, for the defendants to show some concrete evidence. Some burden on the plaintiffs, to be sure, some concrete evidence of anti-competitive effects, but not conclusively prove them when the defendants, in fact, have not come up with any concrete evidence on pro-competitive effects. One last thing, Eric Coons, I guess, asks on the chat, would this proposed rulemaking, would it be a violation by the buyers as well? My reading, at least, of the open market proposal is no. It seems like the per se rule would only apply to the party imposing the exclusive contracts on a set of buyers.
Okay, I think I said that we'll go to Dennis and then Abe and Doug. If you have closing remarks, so to speak.
Okay, I'll try and be brief. Let me just echo what Jay said. Janusz died untimely early death, and everybody's going to miss him. He was smart, and he was also lots of fun. Here's my view. I'm an economist, so I can't talk about legal process. As an economist, I'm going to trade off the harm from the benefit. And it makes me a little uncomfortable to start doing one before I do the other. I'm going to do them together. That's how an economist thinks. I understand legal process is different. What has bothered me about a lot of vertical cases is they start with market definition. And in part, that's to get summary judgment and the like. So now we are focused on market definition, and we are not focused on conduct. And that has always bothered me a lot, even when there are very good natural experiments of the conduct changing, and therefore you can tell what's going on, even when you get to the merits, the merits phase. Second, and Doug said something about discounts. Again, I want to reemphasize, discounts can be a way to get exclusive distribution. And then if discounts are allowed, as even the OMI seems to indicate, it's just complicated. I'll end it. I'll just say that. What was that? I was on a congressional commission. I can't remember. The Antitrust Modernization Commission has a long discussion of that. The Section 2 guidelines that were withdrawn when Christine Varney became the Assistant Attorney General also had a very good discussion of that. But I wanted to raise one point, so it's not really quite summary, but I think it's an important point. It hasn't been mentioned. If a manufacturer and a distributor engage in some relationship that forecloses entry into manufacturing, that could help the distributor, because the manufacturer can give some of his monopoly profits to the distributor for doing that for him. Okay? I've never seen a case in which both people get sued. Now, obviously, that's going to depend on the circumstances, but some of these vertical cases with harms to competition involve bilateral contracting at different stages, and both stages can be culpable. Finally, the no economic sense test, I've said this in writing, sometimes works, sometimes doesn't. And if you ask me, gee, I'm advertising, and why are you advertising, Carlton? Is to hurt your competitor? I'll say, damn right it's to hurt my competitor. I want to get sales from him. Well, if he didn't exist, would you do it? Probably not to the same extent. So you got to be real careful how you interpret the no economic sense test. It has many good features, but I don't think it's the end all and be all. And finally, I would just conclude with what I started with. I think a per se rule, as OMI is suggesting, based on market shares as low as 30%, is really a recipe for disaster.
Okay, Abe, any final comments?
Just briefly, I mean, I think, most of us seem to be in agreement that a per se rule makes no sense. I think, however, if we want to, and I think people need to kind of advance this middle road of antitrust, policy. We do have somewhat of a burden to try to come up with sensible alternatives, right? I think what's driving this is that we have the right structure, but the structure seems to be underweighting anti-competitive effects, and I think it's a mistake to change the structure. I think it's the only structure that's possible, but some sort of way to get to make it easier to bring these cases, I think would be desirable, both on its own merits, and I think also to try to put a stop to some of these more extreme proposals that I think that all of us agree are misguided.
All right, I'll turn it over to Doug, and then I'll make.
Yeah, I'll be very brief. So a couple of people said, Einer said, foreclosure is a loaded word, and courts have read it to mean, really foreclose as opposed to handicap or something. We got to do something about that. Dennis talked about the importance of looking at both the pluses and the minuses simultaneously. I think with these two comments and many of the other comments that you folks have made, have in common is a realization that antitrust laws become very complicated, and there are a lot of pitfalls. Courts have trouble understanding how you define a market, what is foreclosure of what, and so on. Maybe the solution is not to go in the direction of codification, whether by presumption shifting or by per se rules, but to go the other way and say, wait a minute, antitrust is about anti-competitive conduct that increases market power. By the way, I misspoke. The test on no economic sense test would you be doing this if you couldn't increase your market power? But be that as it may, I see those are the two elements of all antitrust offenses. What if we put them to a court? And the court's going to have to look at the facts without the baggage of words like foreclosure and all that, and say, is this exclusive dealing giving the defendant increased market power? And if so, is that because he earned it on the merits because it increased his efficiency, or because it kneecapped his rivals? And I think it may be that antitrust ought to go in the other direction. I just put that out for thought. I'm not convinced it's the right solution, but it's something to think about. And by the way, if we had an exclusive dealing or other vertical arrangement that falls into the category, the subset of exclusive dealing, in which you can say, in the kind of Actavis sense, gee, the distributor is being paid, you share in the monopoly rents with the defendant. That's the case for both parties, it seems to be, are proper defendants, not the dense play case. That's it.
Okay, well, I'll say thank you to everyone. I played the role I like to play as moderator, which is very little role, and let the experts talk. There's one question I would have put to everybody had I sort of thought about it earlier, or we had time, but maybe there's some, maybe it's been touched on. My view is the courts seem to pay attention to one type of error cost, over enforcement, And the one change that would make a big difference in the cases is if the courts were more sensitive to, minimizing the sum of the error costs. And I think that would be hard, but that seems to me to be the driver of some of these errors. The failure, as Einer had sort of articulated first, but I think everybody agreed, which is that plaintiffs are put to a pretty high burden, and defendants, either often or more than sometimes, are just able to say we have an efficiency without actually showing that or proving it. And I think this would have the benefit too of not only putting defendants to the test of their efficiencies and flushing out, just false statements in a sense of efficiencies, but also put some rigor behind efficiency analysis generally, right? I mean, the merger guidelines include an efficiency section, but in the roughly 25 years they've been in there, both in my time as a practitioner and in the agency, sort of wondered how thorough the efficiency analysis is by both parties. And so, I think greater emphasis on efficiencies will not only harm defendants, as some of the comments or somebody might take from the comments, but I think in fact improve antitrust law by actually struggling with how to treat efficiencies and how to balance them against at least potential or harms. So I'll stop there. It's maybe a discussion for another panel. But when I'm asked, what's the one thing that could be done, rules, new legislation, whatever, I say just get the courts to focus on minimizing the sum of the errors and not where I think they are today, which is focused on preventing over deterrence. I'll stop there. Thank everybody. Thank the attendees. Thank the panelists, and hopefully we'll have the recording up on the website so people can view this, return to it, and use it really in their discussions with agencies and courts and the like about the difficulty of one size fits all approach to some of this stuff. All right. Thank you, everybody.